Welcome, everyone. This is the first workshop of the year for the February 2025 Florida bar exam. I was just explaining to the class that the spirit animal is wolf. Recommend this book, The Rise of Wolf 8. The song of the administration is Florida with 3 exclamation points by Taylor Swift. And I'm trying to have the chill guy vibe from the meme, the chill guy meme. If you don't know what that meme is, then you have to look it up yourself. All right, so we're gonna work on a workshop today, but we have the luxury of checking out workshops that I've done from the past, right? Before we even begin our own quest. So the workshops that I've done in the past are all here on the July 2024 essay workshops. If you have any access issues, just reach out to me or your customer service representative, and we'll show you how to access these things. But it's in the classroom. You scroll down for classwork, and it's like previous, it's called July 2024 essay workshops. And we're going to look at contracts. We have the Florida contracts questionnaire, which like I told you all to memorize last time. So you kind of refresh, like want to know what is a contract, UCC for goods, common law for real estate and services, goods are all things movable, unilateral accepted by performance, bilateral contract formation. We want to have definitions of offer, acceptance, and consideration. Be on the lookout for if it's like a newspaper article, is it just an advertisement, invitation to deal, or could it constitute an offer if it's very specific in the terms of how to accept? Special rules that apply to merchants, if they say, Tommy, what was I forget what fruit I was using. I was trying to be consistent. Tommy, a strawberry salesman. It wasn't strawberry, but Tommy, a strawberry salesman, and Susie, a strawberry retail buyer, right? It signifies they're merchants. And if they give you a buzzword, like they wouldn't tell you that Tommy is a strawberry salesman unless it was to give you the opportunity to write about why it's important that he's a merchant. And there's special rules that apply to merchants, like the firm offer rule, the ballot of forms provision, the merchant confirmatory memo rule, the perfect tender rule, the 30-day request for further assurances rule, and the no consideration required for modification. These are like rules that you can keep in mind that you may want to talk about at the beginning. So, buy friends drinks, big drinks, body of law, formation. We've already talked about these things at the beginning of the contract. And like, what type of contract is it? Is it an installment contract, a unilateral, bilateral contract, a requirements contract, an options contract? Try to like give the reader information that you understand contract law. You can think about the predominant purpose test, mirror image rule, ballot of forms provision, perfect tender rule. These are buzzworthy things that you could talk about in essays. Under the common law, we have the mirror image rule. The terms of the offer must match the terms of the acceptance exactly. And under the UCC, well, the ballot of forms provision, where an additional term, so long as it's not material, will be included in the contract. If it is material, or if it's material, it'll probably be a counter offer. If it's a conflicting term, it'll be knocked out and we'll apply the UCC gap fillers. I'll slow that down for a second. So like if we have an offer under the UCC and then the acceptance has an additional term, you're going to just make the argument. Is the term material or immaterial? If it's material, then it's like, okay, that's a counteroffer. If it's immaterial, it'll be included in the contract because that's how the rule works. Unless it's conflicting with like another term. If it's a conflicting term, then we'll still have a contract, but they'll knock those terms out and apply UCC gap fillers, which would be like what is common in the industry or custom. The reason for this battle of the forms provision is we want to have contracts between merchants. We want to have, contracts under the UCC where we're not like saying there's no contract because of a small provision in some form in the acceptance. Statute of frauds, we're going to see when we do some essays today, comes up in every essay for contracts. Always talk about statute of frauds, and I recommend not just being like, the issue is whether the statute of frauds applies. Here, this is a contract for goods over $500, therefore it must be in writing. I personally recommend trying to get your points. The issue is whether the contract must be in writing under the statute of frauds. Under the statute of frauds, there are certain contracts that must be in writing and signed by the party to be charged. These contracts include contracts in consideration of marriage, contracts for land, contracts that cannot be completed within 1 year, executorships, goods over $500, and suretyships. I said them out of order, but it doesn't matter because you're not saying the mnemonic, you're just saying the phrases. And then you'll say here, because the contract is for goods over $500, it must conform with the statute of frauds and be in writing. Even though you might get the exact same amount of points, like can you say you'll definitely get more points for mentioning the other types of contracts that must be in writing? Maybe, maybe not, but I would err on the side of maybe you'll get more points, right? That's why I kind of have these like, I used to say this a lot. And I try not to be a broken record. So if you see my old videos, I try to say different things, but I used to say this a lot. The Florida essays are like I used to have this Woody doll when I was a kid from Toy Story, where if you pulled the back out of it, and then it would say like, "Hi, I'm Woody." Like, "What's up, Buzz Lightyear?" It would have like this thing that it would say. That's exactly how these essays are. You just want to like pull a string out of your back and then just write down the things that you know you're supposed to write about. So when I see statute of frauds, I do the my legs mnemonic, contracts in contemplation of marriage, contracts that cannot be complete with 1 year, contracts for land, executorships, goods over $500 and suretyships. And then I immediately get into the swap mnemonic, right? How it's possible to overcome a statute of frauds defense, especially manufactured goods, written confirmatory memo, admission in court, promissory estoppel, and partial performance. And then I say here, because the goods were engraved with Tommy's name in it, he will argue that they were specially manufactured goods and therefore did not be in writing. Alternatively, that's a good little word. Alternatively, Tommy could argue that although it was not in writing, he had relied on the goods and had already found new buyers and went out and bought a boat or whatever it may be. Like you can say, therefore, under the theory of promissory estoppel, since there was detrimental reliance, the contract would be an exception to the statute of frauds. On balance, the court would likely find that either under the specially manufactured goods exception or the theory of promissory estoppel, the contract did not be in writing. Therefore, there was likely a valid contract between the parties. In general, there's likely a valid contract between the parties, right? Because then if there wasn't, there's no conversation of breach, there's no conversation of damages. You kind of just like stop writing the essay. I would bet if I was a gambler that they would want you to keep writing the essay. And so like think about that. If you're like, well, it should have been in writing, but why should it maybe not have been in writing? Lean towards there's probably an exception. There's probably a contract just because we're writing a contract essay. But understand that's like the first conversation is, body of law, UCC common law, formation, offer acceptance, consideration, and then defenses. And the main defense you'll always talk about is statute of frauds and kind of, have that in your mind. Statute of frauds, my legs are the contracts it applies to, and then swap is the mnemonic for exceptions, especially manufactured goods, written confirmatory memo, admission in court, promissory estoppel, and partial performance. Some other defenses you see, mutual and unilateral mistake, you want to just argue for things. Like the more things you can argue for, the more points you can potentially get. So just remember all the different defenses, and like you don't want to just necessarily list them in a list, but you kind of want to, write about defenses that may apply. And the more you can conceivably apply, the better. Even if it's a weak argument, I would still write it out. Like Tommy will argue that there was a mutual mistake. However, the facts show that Johnny knew exactly what he was getting himself into, therefore this argument would fail. You took 30 seconds to write that, and it could have got you a point. I think people really struggle with that idea of like writing counter arguments, writing weak arguments, writing failing arguments. But remember, as an attorney, a lot of times you represent the criminal, you represent the fraudster, you represent, I mean, honestly, that's where the big money is, right? Like, and most of you got into law to make money, so you should get used to having to argue for the insurance company, right? Like, we shouldn't have to pay out the claim to save poor Grandma Susie because that's what we're arguing for. So like just get yourself in the mindset of like arguing both sides, why there would be a contract, why there might be a defense that would say there was no formation or execution. And then don't be so tied down to what's right or what's wrong. Allow the reader to kind of like decide. And a common, way of doing, a way that we do that is say, on balance, the court would likely find. That kind of makes you less like, if you're wrong, at least you just said the court would likely find. You left the door open for the court also finding the other way. If you just say, here, there's a breach of contract by Tommy and the court will award expectation damages. What if the actual essay is that there was no contract and no damages should have been awarded? You're going to leave a bad taste in the reader's mind, bad taste in their mind, I guess that's poetic, immediately, because you're wrong and you're going to be wrong on some things. It's a hard question. These questions are kind of up for interpretation in general. So like, don't be so passionate about what's right and wrong. Be more explanatory and explain what both sides would argue. And for those of you, Safwan and Nat, who've taken UC or have taken UBE or California, it's a little bit different. California and UBE, there is a little bit more right to the point. Like, this is what the issue is, this is the rule, this is who would win, and this is why. Florida is a little bit more of arguing both sides and trying to have a more sweeping approach to get more potential points. And you'll see that when we go over some practice essays. So some, other defenses, acquiescence, like you allowed it to occur. It's very rare that that's ever come up in a Florida essay. I don't think I've ever actually seen it, but can't hurt to know. It's ambiguous, right? There's duress, which is a threat, fraud, concealment or intentional deceit, frustration of purpose. Like, it can be completed, but it would be, not prudent to continue to do so. Incapacity, mental infirmities, inability to comprehend, illusory, empty promise, impossibility, we can't do it, it's on fire. Impracticability would be very difficult to complete, prices have gone up so dramatically. Infancy, too young. Intoxication, too drunk. Or too high, too under the influence. Latches, too late. Misrepresentation, intentionally or negligently making statements that are not adequate. Unclean hands, you participate in bad behavior. Unconscionability, procedural or substantive unfair terms or unfair bargaining power. And then undue influence, taking advantage of a special relationship. And we already discussed statute fraud, mutual stake, unilateral mistake. This is really solid. Like, we did a good job in this workshop. What's the difference between material and immaterial breach? Material gives rise to rescission, reformation, avoidability. Immaterial breach is just minor damages. People fail to talk about the breach, but the breach must be mentioned. That's why there's a claim, right? What's the difference between equitable and legal relief? Equitable is court ordered, legal is monetary. What are all different types of relief under contract defense? Compensatory, like expectation, consequential, incidental, nominal, lost wages, lost profits, restitution. Equitable relief is injunction, specific performance, reformation, rescission, replevin, I guess. Quasi-contract, promissory estoppel, and punitive damages. Replevin is an action to get back stolen goods. So yeah, I guess there could be an action in replevin in some contract claim. I wouldn't stick to that. I would stick to the big ones: specific performance, reformation, rescission for equitable relief, compensatory relief, expectation, consequential, incidental. Remember, consequential damages need to be foreseeable in light of a breach. Expectation damages are to put the non-breaching party in the position they would be if the contract was performed. Mitigation is a big word. Mitigation, mitigation, mitigation. Talk about mitigation. And then I just like laugh at myself sometimes. And then cost of cover, like if it's about goods and you have to go out into the open market. So you can get points for mentioning cost of cover, mitigation, and talking about damages and that discussion. People lose points on damages because it comes at the end of the essay usually. Sometimes I recommend writing about it first, like just go right to, prong 4 and be like, damages. At contract law, there are two types of relief: legal and equitable. Legal relief is monetary, equitable relief is court ordered. The main types of legal relief are expectation damages to put the non-breaching party in the position they would be if the contract was performed, consequential damages, which must be foreseeable, and incidental damages, which are to recover for mitigating the breach. Equitable relief includes specific performance, reformation, rescission, and injunctive relief, period. And then go back and write the essay. And then by the time you get to prong number 4, you're like, oh, nice, I already wrote all that. You're going to write that on every essay. So now you can be like, here, expectation damages would be the best measure. Tommy will argue that he XYZ, cost of cover, ABC, whatever it may be, but it's just like, you can game the essays a little bit and like, if you see something that you know you're gonna have to write about and you already have like a canned, you know, definition for it, then maybe start writing it first and then fill out your essay. The reader's going to read it from top to bottom. They don't know how your essay was constructed. That's kind of like a high level approach to essay writing that, you know, might not resonate with everyone, but I do that sometimes. I don't always write things from top to bottom. I kind of write things, you know, patched together and then create the essay for the reader to read top to um, so what are the requirements of non-compete? It's got to be reasonable in geographic scope, subject matter and duration for sure. We talked about different types of contracts, options contract, like they'll remain open. You need consideration at common law, but under the UCC, we'll have the firm offer rule, which there's no consideration necessary. It'll remain open for a specified time period or up to 90 days, after which it becomes revocable. Requirements contract, so we'll produce all that's needed, like whatever you need, we'll produce. An output contract, we'll buy all that's produced, like whatever you produce, we'll buy. Installment contract over sequences or batches, and there could be opportunity to cure. Look for firm offer rule I just talked about, up to 90 days if not otherwise stated, between merchants to stay open, no consideration necessary. The mailbox rule, if they talk about a letter in the mail, you know, they tee up these issues. If you see like Tommy put a letter and stamped it and then Johnny received it and XYZ, they're looking for the mailbox rule. Offers are effective upon receipt, acceptances are effective upon dispatch. It's the main tenet of the mailbox rule. Liquidate damages, to contemplate damages in advance because they'd be too speculative in light of a breach. They must be reasonable, typically limited to 20% of the contract price in Florida, but you know, it's case by case matter. They cannot operate as a penalty. Anticipatory repudiation, unequivocal intent not to honor the obligations of a contract. So, you know, Tommy will argue that Susie anticipatory repudiated the contract when she said that she was thinking about not delivering the goods. However, this was not an unequivocal statement of an intent not to honor the obligations of the contract because she merely said she was just thinking about not delivering the goods. Therefore, you know, an anticipatory repudiation did not occur. There may be reason to send a request for further assurances in which Susie would have 30 days as a merchant to respond to. However, she could argue that her statement did not give rise to sufficient insecurity. On balance, the court would likely find that the statement did give rise to insecurity. Therefore, it would be appropriate to send a request for further assurances. However, there had not yet been a clear and unequivocal anticipatory repudiation. Right, you kind of just flow through these essays nice and neatly, using the buzzwords, saying the definitions, nothing too hard about it. Parole evidence, I think that comes up a decent amount. Like, we're not gonna admit extraneous evidence to contradict a fully integrated contract. So like, we're gonna look at the four corners of the contract and determine what the parties intended, but we will allow outside evidence to like supplement the contract in terms of explaining an ambiguous term or showing that there was a condition to execution or showing there was a defect in formation or showing customer trade usage or showing an additional term. As long as it's not conflicting the contract, like the contract's for apples and now you're saying it was for oranges, oh, like that's conflicting. But if it says the contract's for apples and it said you would include blueberries, well, that evidence of including blueberries is additional, and that might be included as an exception to the pro evidence rule. So what other topics do you anticipate being tested? You know, exceptions to pro evidence rule, we just talked about that. Maybe like third-party beneficiaries, you know, TPBs, their rights can vest if they're that they rely on the contract or they sue under the contract. Those are parties that are intended to benefit from the contract, intended beneficiary. And then maybe like court and satisfaction, which is like a agreement to pay down a debt, right? Like you have an agreement, you owed someone $1,000, now you agree to pay off $500 to extinguish the earlier debt. The accord is the agreement, the satisfaction is the actual payment of that amount. Okay,
Hey, Andrew.
so yeah, that's me. What's up?
Quick question. If for like the mailbox thing, for people who are accepting, obviously revocations are effective when they are received. But if the person who accepted, it's effective upon dispatch, if they wanted to revoke their acceptance, is the only way for that to do that is for the revocation to get there before the mailbox? Like if you have both from the person who's accepting
Yeah.
opposed to the inverse?
I mean, I've seen this question. That's the only way I can envision it is like Tommy sends an offer to Johnny, Johnny mails back an acceptance, and then a day later mails a revocation of that acceptance. Is that what you're talking about?
Yeah.
It would be
But re-
whatever
revoking is
it would be when everyone arrives first in that
okay.
situation.
Okay. Thank you.
Yeah. I hate how they test that because it's like, when does that ever happen? And like, who's really doing things in the mailbox with telephones and, AOL, AIM Instant Messenger? Isn't that how you guys communicate? AIM? AIM? You're laughing, Saffron. You ever had AIM Instant Messenger?
No, that was way before my time.
Don't say it was way before your time because I was in the
AIM,
heart
AIM doesn't
of,
even exist anymore.
I was in the heart of the AIM era, and like we had away messages, like we used to do chat rooms, and then like, okay, so we would all be in the chat room, like only the cool kids, obviously. And then like someone would we would all be in the chat room, we'd have this outrageous conversation, and then whoever had a printer, which was like a luxury, would print it out the next day, and then they'd bring it to the cafeteria and they'd have like multiple copies of it, and all the kids would be like reading the conversation from the day before, and like the look of kids' faces who either like weren't cool enough to be in the group chat or like couldn't make it that night, or like their moms wouldn't let them, like whatever reason, was just like horror, like, oh my God, like there was a group chat last night on AOL Instant Messenger, and like I wasn't part of it, and now I have to read and like look at these hilarious comments the kids were making. Like, I don't know if those were the good days or not, but those were the days that I grew up in. Okay, so anyway, let's talk about this essay workshop, 5/18/24. So we did this but a few months ago. What about issue spotting generally? Issue spot, IRAOC, issue rule analysis conclusion, cleanly organized with subheadings and bolding key terms. When in doubt, write it out. I like to say that. Time management, practice, practice, practice. You have 1 hour per essay unless you have a time extension, but like, know your time extension and account for that, and try to do it in under time circumstances and practice. And honestly, try to do it even quicker so that you give yourself some grace on test day, because I don't know if you know this, but like people get nervous, nerves get the best of you. It's pretty crazy being in that big old room with all these like heavy breathing mouth breathers, and like it's just a lot. So like you lose time a little bit. Maybe you have to go to the bathroom or something. So like try to do it in 50 minutes, and then just give yourself some grace that like, that's how it's going to be on test day. So um, contracts we talked about can be tested with other subjects. Buy friends drinks, big drinks. We talked about that a lot. Always explain the mirror image versus battle of the forms. Not always, but like, that's pretty common. Look out for merchants and define and explain the importance of merchants. Try to identify the type of contract, like bilateral, unilateral, installment, divisible, options, requirement, output, etc. Write about statute of frauds, my legs and swap. We talked about this. Mistake is another common defense. A lot of defenses start with illusory, illegality, incapacity, infancy, intoxication, impracticality, impossibility, etc. Look out for fraud, duress, misrepresentation, concealment, etc. Always write about expectation damages and alternatively specific performance. Try to mention modifications, mistake, reformation, rescission, detrimental reliance. Look out for parole evidence, anticipatory repudiation, liquidated damages, accord and satisfaction, non-competes. Remember that both parties will probably argue that the opposing parties breached the contract, right? You're going to argue both sides. So we issue spotted some essays. We're going to do different essays today. I can't do the same essays every year. I drive myself crazy, right? Got to have some variation in life. But these are the essays we spotted in the past. And it was July 2021, and kind of let's see what we thought. I said this memorandum will discuss. I like to set my essays up like that. Like, I do it very old fashioned. I'll be like to, from, read, date, then I'll do like a freaking line, and then I'll go, this memo will discuss, and then I'll drop all the claims, and then I'll organize them by heading. Like, I'm very meticulous in how I write essays, but like that's a luxury of me being able to write essays really fast. Like if you don't have time to do it like that, this is how I would do your essay. This memorandum will discuss, and then just drop the claims from the actual call to question. Bella's claims, any arguments that Sharon had, Laura's representation of Bella. I may have assigned this essay. I don't know. So if I did, like, I should be helping you with your homework. It's all good. It's all about repetition and reinforcement. So this agreement is between BNS under the UCC because it's for art and it's good, all things movable. Article 2 of the UCC governs contracts for goods, common laws for real estate services. It is important to note, that's like my favorite saying, that since Bella is an art dealer and Sharon is a renowned photographer, Both parties are considered merchants under the UCC. People who commonly deal with goods in the contract, right? I define merchants, got myself a little point there, and thus will be held to special rules that apply to merchants. This contract was a bilateral contract that required the necessary elements of contract formation, offer acceptance consideration, no valid defenses. Here, despite defenses Sharon may raise, a valid contract was likely formed between the parties, and ultimately Bella should be able to recover damages. Like I probably wrote this in class, like on the fly. It's not perfect, but it's like, you know, the shoe fits, it'll do fine. So Bella may validly bring a claim against Sharon for breach of contract for the non-conforming tender Panthers won. And then, you know, these are probably the issues we spotted when we read the essay. UCC versus common law, goods, merchants, contract formation. We did it chronologically. Merchant confirmatory memo rule, which in my mind brought up the swap mnemonic, mistake, unilateral versus mutual, parole evidence, reformation, perfect tender rule, non-conforming goods, breach specific performance. Those are all solid pieces. Sharon's arguments were like modification, statute of frauds, liquidated damages. You know, maybe there's no signature, which is kind of a weak argument. Request for return signature is an issue. And then some ethical issues, right? All right, and then next is torts. Ew, gross. Actually, I like torts. Contracts is kind of gross. Not really. I actually like contracts and torts. I'd say real property and con law are gross in terms of essays. So that was an essay we did. That was kind of fun. We're gonna do the exact same thing today as a class. And you know you have some homework assigned. Let me just see exactly what the homework was, so we don't do those essays, even if we just went over that one. And then we'll do some issue spotting, and we're gonna have a really fun time. So just as you should all know, there are assignments to the course, and February contracts that were assigned were July 2016 and Feb 2023. So I'll try to avoid those. All right, good. So that's not even the essays that was assigned. That was a good essay that you could do. The more essays, the better. But like these are the assigned essays. 0 people have turned it in, which is good because you should wait to do the workshop today. And then write your essays under time conditions, turn them in, and I'll give you my grades as soon as possible. My grading system, I've gotten like harsher over the years, so don't take it personally. I used to give people like 80s, and then their actual score would be like a 42, and I'm like, okay, well, I'm not going to give people grades that they're not going to get on the actual exam. I really try to give you the grade that I think you would have gotten by the FBBE, and they're pretty tough. So like, you know, I think like a 40 means you pretty much pass bare minimum. 50 is like a good essay, 60 is like a great essay, 70 is like a grand essay, and 80 is like a wonderful essay. That's actually a reference to a 90s movie that probably nobody gets, but that's my grading system. So it's like 40 is good, and then all the way up to like 80 is like the best you could ever do. You really aren't going to get many people getting 70s and 80s. You should feel good if you got like a 62. That means like you really got it going on. If you failed, like that probably means that you probably would have failed on test day. It's nothing personal. It's just like you want to know that, you know, nothing, you know, be very realistic. That's the plan. Okay, so
Andrew, how will we know once our essay has been graded? Is that something that you communicate to us directly, or
you'll get a notification in the classroom. Like
okay?
that's why we do the Google Classroom. It's super easy. Like it'll be like your essay has been graded, and then I'll give you a score. I'll give you feedback. My feedback is mostly just like spotting the issues that you missed, and then I might copy and paste some language from the actual essay. I usually, you know, put a link to the model answer. I mean, it's not that hard to grade your essays and see what you did wrong. Just pretty much compare it to the model answer. But like, you know, the most important thing is the score I give you just as like an idea, and then I'll give you some feedback about like what you should do. Usually I'll say things like try to write more. I know that's very obvious, but like the more you write, the better chances you have of passing. I think like you should strive for like 2,000 word essays, 10,000 characters. It's not easy to do. You can certainly pass writing 1,000 words. Like, you know, I've seen model essays that are like 850 words, but like the best of the best essays are like 2,000 plus word essays. And, you know, don't be intimidated by the model answers. I tend to think that a lot of people had time extensions who wrote the model answers, and that kind of like is an unfair comparison, you know? Like that's the best essay that was written that year, and it may have been written with like double the time. So like, you know, don't compare yourself in sense that like I need to write essays as good as the model answers, but strive to, you know, like if you're an athlete, you should try to mimic the best athletes. When we were kids, I'm gonna date myself fucking again, but luckily there's 2 people in the room older than me, at least, maybe 3 or 4. It was Ken Griffey Jr. for baseball. We used to like watch his videos of him swinging the baseball bat, and we would all try to like be like, "Look, my swing looks exactly like it," and like obviously it didn't, but like yeah, that was a good way to get better. Try to emulate the models. That's like good advice for life. Okay, so here I'll share this with the whole class. I'll put it in the classroom. It's going to be called essay workshop 12/7/2024. Where has the time gone, right? And we are gonna pick an essay. I guess we can do as recent as possible. What I say was February 2023 I signed, so let's not do that. All right, this one's contracts and torts. I'll probably do one that's just purely contracts, just so we can like focus on contracts. This is the one I assigned February 2023. So as nice as it would be for me to like go over it, so you guys all wrote perfect essays, I'd rather see how you guys actually do. How about this one, July 2021? That's when we just did as a last administration. So that's the art dealer one. That one was good. That one you guys should all refer back to. We'll jump back a little bit further in time. October 2020 is this. I didn't assign this one, right? No, I don't think so. Let's just make 100% sure. I assigned Feb and July 2016. All right, this is the perfect essay to do. Are y'all ready? So what we're gonna do is issue spot. That's the most critical thing. You want to get really good at honing in this skill. So we read the call to question first. Prepare a memo for a senior lawyer in your firm that discusses Abby's claims against Sunco, Bob's claims against Sunco, and Sunco's claims against Bob. You should assume that Bob had authority to enter into an agreement with Abby and disregard any issues related to FTC regulations, thank God, on sponsored social media posts. Cool, social media. So this is what we're asking us to do. If it was me, I mean, I'm going to show you how I would do it just because I'm like, old fashioned, I guess. I would say to senior lawyer. So my grandfather taught me, right? From, I would say, examinee, right? Like, you don't want to put your name on it, right? Don't do anything too stupid. Claims regarding Abby, and I might even do this early on. I like making all my people A's, S's, Abby, Sunco, and looks like Bob, right? Very creative. You don't really see people named Bob anymore these days. And Bob. I mean, you can do this a million ways, but to me, this is just like a very formulaic way I do it because now I can just do A, S, and B the whole time I'm talking. And then date, always like the date. Time still undefeated is now 12/7/2024. And that guy from Home Alone is president. When the aliens are listening, in 1,000 years. He did it. I think I can't predict who's gonna be president in 20 years. Okay, so then I would start off with like this memo will discuss, and then I'm just gonna like copy and paste it, right? Like this memo will discuss these 3 things, and then those 3 things are gonna become my headings, right? AVS, BVS, SVB, right? Like I've already just like very methodically, chill guy vibes, just structured my essay. So that like takes a lot of the pain out of it. And now when we issue spot, I could just like, drop the issues, I'm just kind of assuming. I could just drop the issues like where they're gonna appear on the essay. It makes it really easy to just piece it together, right? And then it says, I should assume that Bob had authority to enter an agreement with Abby and disregard any issues. Okay, I'm just gonna keep this stuff at the top right now to just like remind me, but we don't really need it. Is anyone else annoyed at Arial 11? What do we use? Times New Roman? Is that still what? That's what we used to use back in my day. I don't know what you guys use. Helvetica is for like businesses to like subconsciously sell you stuff. and then Times New Roman is for school. That's what I always learned. Okay, so, and 12, it's gotta be size 12. That's like code. That's how we're gonna start. Anyone have any questions? I mean, that's how I would start it. You're free to start it your own way, but like, I made it look super nice. I said what the memo would discuss. I organized it exactly as the question was asked. That way I'm not gonna veer off topic. You know, that's a pretty good way to do it. Good? Okay, what I would do now is we're gonna issue spot, you know, and every sentence has a purpose, like, we gotta try to tease out as many issues as we possibly can. So let's just kind of do that from the beginning. I'll be the first reader and then I'll popcorn and someone else can read and we can like issue spot, but let's kind of do first paragraph. So Sunco needed a marketing manager to help with launching Cool Shades. Very, really great name. A new line of sunglasses. Sunco interviewed Bob and offered him a $75,000 salary. Bob told Sunco that he would consider the offer, but that another employer had offered him a comparable salary with a bonus opportunity for hitting sales targets. Sunco's president told Bob that if sales of Cool Shades reached 1 million within 18 months, then Sunco would pay Bob a bonus equal to 5% of the total sales of Cool Shades. Bob replied, "You have a deal." So anything anyone notices in the first paragraph that could lead to points? Any issues we could spot?
There's a condition there to know. for
Yeah,
any-
there's definitely a condition, right? So let's put that, and this is Bob and Sun, right?
Also an employment contract.
Yeah, there was a condition to contract execution. There was employment contract. And it had the necessary term, right? Because it had the salary term.
Yes.
That's a good thing to note. So they interviewed him and they offered him, and he said he would consider the offer. So that first communication, right? First communication, he would consider the offer was not an acceptance, right?
Yeah, you have an offer and a counter offer almost with acceptance.
We definitely have the offer, which was,
No.
yeah, the freaking offered him $75,000 salary. And then he would consider it, but he had another thing. So that right there, it was not an acceptance, nor was it a rejection that terminated the offer. Right? Like some people might think it was, you could argue that back and forth, but it really wasn't. It was just like, I'll consider it, but it wasn't like, no, now the offer has been, revoked. Like the offer still, we would think remains open and still acceptable. Then we kind of have a new offer, which is if you reach 1 million within 18 months, then he would pay a bonus of 5% of the total sales of Cool Shades. He said you have a deal. So that's an acceptance, right? Acceptance, you have a deal. All right, let's look a little bit deeper. Anything we notice at all, like other things maybe that might spot issues? I mean, that might be issues. What about that piece right there? 18 months. Why'd they tell 18 months? That's a random number.
Statute of frauds.
Mhm.
Contracts that cannot be completed in 1 year.
Yeah, I think SOF for 18 months. Like they wouldn't have said 18 months for no reason, right?
And
Bonus
then-
equal to 5%. Go ahead.
If an employment contract has a time, then it's no longer at will.
Yeah, exactly. Right. So I like that salary term, usually at will. However, here 18-month term potentially. I mean, again, these are all just issue spotting. When we issue spot, we don't really make conclusions, right? We listen and we don't judge. We just spot issues and see what could potentially come up. So pretty solid, right? We got Sunco and Bob. Pretty much we got a little contract situation with the contingency 18-month type deal. The next day, Bob quickly reviewed and signed an employment agreement that stated salary, but did not include any language about a bonus. Okay, what does that kind of implicate already?
Parole
You're ringing
evidence.
the bell for promissory estoppel, I think, like reliance
well,
on
I like-
promise.
Parole evidence first. That was smart. I mean, everything's smart, but let's just one piece at a time. Parole evidence because missing oral agreement about what did they say it was about? about the bonus. Language. It's not the best thing. So we potentially have parole evidence, and then someone else was saying maybe we have a promissory estoppel thing because of reliance. Is that what you're saying?
Yeah. I mean, they're relying on their detriment, essentially taking this job as opposed to the other one.
Right, exactly. That's why they mentioned that he had another opportunity with another employer. So good point. Reliance had opportunity. Okay, potentially. It did not include any language about the bonus. The agreement provided that Bob would not agree not to compete with Sunco in Florida for at least 6 months after leaving Sunco. All right, what's that sound like?
Non-compete clause.
Non-compete, and we already know they need to be what? Reasonable and what?
Geographic scope, duration, and specialty.
Right, reasonable in geographic scope, subject matter, and duration. And here, I mean, just like off the bat, what seems 6 months after leaving, I mean, that could be reasonable. It's like, doesn't sound like too long, but we'll have to see. All right, it also stated, let's see what else we got. The agreement constitutes the complete agreement between the parties with respect to the subject matter contained herein and revokes and supersedes all prior simultaneous representations, discussions, negotiations, and agreements, whether written or oral. So what is that called?
It's a merger.
Yeah, it's a merger clause. It's fully integrated. That's all gonna, implicate parole evidence. We're gonna have a parole evidence discussion. Cool. Sounds like the most fun. It's Saturday and the Hurricanes are not playing football because we lost to Syracuse. Just realized that. How droll. In his first 2 months on the job, Bob struggled to generate sales of cool shades. Yeah, I mean, who's buying cool shades? He then noticed his daughter following Abby on social media. His daughter explained that Abby was a 21-year-old influencer with 480,000 followers and that, who writes these things? And that some companies would pay Abby to endorse their products or post photographs of her using their products. All right, so Bob's struggling. Now he's auctioning off his daughter, right? His daughter following Abby on social media. Who is Abby?
Abby's just an influencer that his daughter follows. So his daughter tells him about Abby.
Oh, so they just called her Abby. It's like it's like a Cher or something. That's like her name. Like, it's like Abby. Okay, I didn't even catch that. Thank you for that. So Abby is like Abby, Beyonce. So she's following Abby, and then he explains that Abby's a 21-year-old influencer. I love they put it in question marks. So she's probably, I guess, OnlyFans model with 480,000 followers that some companies would pay to endorse their products or post photographs of her using their products. Okay, so maybe she's a TikToker. So Bob sent Abby a message through her social media account which said, "Hey Abby, I'm a manager at Sunco. So all right, I'm working for Sunco. We have new sunglasses for you to share with your followers. If you post at least 5 pictures of you wearing cool shades and include our slogan, these shades are cool." And your caption, Sunco will pay you $20,000. What do you say? All right, what does that sound like?
An offer.
Yeah, we definitely have an offer from Bob to Abby. Bob is desperate. So,
Andrew, I got a quick question about the previous paragraph right there. The fact that they're bringing up her age of 21 years old, are they kind of indicating to you that they want you to discuss incapacity based on the age of majority? Because I feel like that's the only time that they've like indicated anyone's age. I mean, even though she obviously is,
Yeah.
she doesn't meet the incapacity issue of being under the age of 18. I mean, are they asking you to basically hit on that?
I love that because maybe, you know what I mean? Like, can't hurt. They didn't say it for no reason. So it is important to note that Abby is 21, therefore she is not a minor and could not argue for incapacity. I mean, like, it can't hurt to write that sentence. Whether it's like they wanted you to write it or not, it's like how many licks will it take to get to the center of a Tootsie Pop. The world will never know, but like you should still write it because they don't take points. It's not like you get off points for writing things. You only get points for writing things. So I would say that, right? Abby's 21. She's not a minor, right? I mean, She got a lot of followers. So then we have an offer, right? Like we definitely have an offer. Now, do you see how I'm saying I'm putting it here? Because A versus S, but S is essentially Bob because Bob is acting, you know, on behalf of S. So that's kind of why I'm just saying this. Now we have an offer when he says, 20K for the foot pictures. I mean, for the pictures, right? I think that's a Freudian slip right there, right? No, I'm just kidding. That was not. That was a joke. I'm not interested in feet. I really don't like feet. That's Rex Ryan's thing, I think. So again, not defamation, just a joke. These are all jokes. Rex Ryan does like feet, like that's a known thing. So anyway, if you post at least 5 pictures of you wearing cool shades, include our slogan, "These shades are cool," in your caption, they'll pay you $20,000. What do you say? What do you say? Abby receives hundreds of direct messages from old men like Bob daily and didn't immediately notice Bob's message. One month after Bob sent the DM, Abby saw the message for the first time. All right, so time has elapsed. She sent Bob a reply which said, "Bob, sounds great. Please send me the money right away." Abby posted 5 more selfies in her cool shades and sent a link to Sunco's website. Get the money, easy. Her followers began posting favorable comments about cool shades and sales increased substantially. Bob was thrilled with the increased web traffic through Abby's link. So Abby, you've done it again. What do we think happened right here?
I think there's an immaterial breach because the next piece of this is that she didn't include the comment, right? But she still created the traffic as requested. So
Okay, we
I
can
mean,
read on.
it's not a complete breach, but it's like, it's an immaterial breach because the Sunco still, received the benefit of the bargain essentially.
You kind of jumped the gun a little bit because, yeah, maybe there's a breach, but do we even have a contract yet?
Oh yeah, fair enough.
So we do have an acceptance, right? We seem to have an acceptance when he says, "Sounds great, please send the money." Like offer was do the thing, and he said, "Sounds great, send the money." And then she actually did. So maybe it's a unilateral acceptance, she accepted by performance, or maybe it's a bilateral acceptance, she accepted by like words. Now, a month had passed, did the offer elapse?
It was never pulled.
Yeah, exactly. It's an
Yeah.
argument. So
Yeah, and there was never a time frame that was specified either for acceptance.
acceptance when she said, "Send the money," right? With a little smiley face and a picture of her feet. And then there's a question of did the offer lapse, right?
Yeah.
And then there's a question of acceptance by performance. Maybe again, I would say detrimental reliance. Like she literally posted these shades are cool and like they don't even seem that cool. She could have blew her whole image based off these lack of coolness. Like I would argue that if I'm arguing for Abby right now. I feel like Abby gets the money, but I don't know. We'll see. Sunco refused because she never included the slogan. Remember the slogan, "These shades are cool." She probably made an executive decision like that's not a cool slogan, right? But she didn't put the slogan in. I would do the same thing if someone asked me to say something not cool. I can't just sell my soul. Then Sunco decided to pay Abby something to avoid negative publicity and sent her a check for $5,000. The check came with a letter to Abby that said check was in full, settlement your claims against Sunco. The check stated payment in full on the memo line. Abby cashed the check immediately after receiving it, but has continued to ask Sunco for the balance of the $20,000 and has threatened a lawsuit to recover for it. So we have what you're saying here is a potential breach because no slogan, right? Then we have payment and acceptance of lesser amount. What could this potentially constitute?
Is that accord and satisfaction?
Potentially, right? I mean, Sunco is going to argue that it was and that she, accepted it because it said that it was in full settlement and said payment in full, and she cashed that check immediately. I mean, again, I'm switching hats here and I'm arguing both sides. I'm pretty good at this. I could probably convince you that either side is going to win right here. That's what makes a great lawyer, let's say. Like you should be able to do that. You should be able to stand in either shoe, Abby or Sunco, and win the argument right now because I think there are valid claims both sides. Like you definitely conned this girl. You got her to post this stuff for $20,000 and then you only paid her 5, and you just sent her this measly little like, payment in full thing, and then how was she supposed to know? You took advantage of her. I mean, but she was 21 years old. I mean, she can read. It said payment in full, and it was an accord and satisfaction. The accord was the offer for 5,000. The satisfaction was the deposit. There's arguments both ways. Let's see what else goes on. So, 6 months after Abby posted about the sunglasses, Cool Shades reached $1 million. Bob asked Sunco's president for the 5% bonus. The president said that she did not recall the conversation about the bonus and refused to pay. Bob was furious, quit immediately, and told the president that he would see her in court. So now we have, Bob and Cool Shades, which is down here. Well, we have Bob's claims against Sunco, and then Sunco's claims against Bob. Well, Sunco is going to claim that, Bob breached the contract when what do they call it? When he rage quit, right? When he rage quit, he breached the contract. B is going to claim that S breached the contract when they didn't pay him the bonus. This is why I run my own business, man. I can't trust these people in these streets. S breached the contract when they didn't pay the bonus, right?
And
Good.
it wasn't in the contract, so.
It wasn't in the contract and is not permitted under parole evidence.
Yeah,
Oh.
but that's innocent.
Good. What did you say?
You have that under Bob.
Wait, what?
Like you're saying that Bob would say that, but Bob wouldn't say that.
Well, it was not in the contract. It's not permitted under parole evidence. But then Bob would reply that it's an exception, right? To parole evidence as an additional term. That's what I would argue. I mean, my argument here is like, actually, we're gonna let this term come in because we're not conflicting and saying that you're supposed to get paid less or more. It's an additional term, and we will allow parole evidence to supplement a fully integrated contract. We just won't allow it to contradict. So I think that's what like they're really getting at with this essay is a pretty, interesting conversation of parole evidence. But we'll see. We'll see what the model answer is saying. So then Bob found a similar position with Spexco. Okay, we like that. What's that called? Finding a similar position.
Mitigating damages.
Yeah, mitigating damages for sure. So I like that. Mitigating damages with Spexco. I mean, that's a cooler name than I don't know.
But then also now S can claim that he's breaching his non-compete.
And then S will write breach of non-compete. And then we're gonna say, was it even enforceable? That's gonna be like one of the questions. This is a great essay. Florida-based competitor of Sunco should have hired Bob. Spexco sales increased because Bob recommended that they use influencers. Oh, that's what Baron Trump recommended. I like my suitcase. Sunco now seeks to prevent Bob from working for Spexco. All right, yeah. So that's the answer. In influencers. That's why I'm worried about influencers. That's influenced the world right now. So that's the essay. Let's look at the model answer. I mean, we teed it up. Like this is what I would do. We know what we're going to talk about, and it would be very much like, Abby's claims against Sunco. So Abby will claim that S breached their contract by only paying, say, 5K instead of 20K. And then you got to go through the whole thing. Like the first issue is whether there was a contract. A contract is an agreement, right? Like I would start agreement between two or more parties in which there are remedies at law. And then I would go into the whole, UCC, common law offer, like you got to get that somewhere. And then down here, you could say like there must be, offer acceptance consideration. You could just say see above. Like you don't have to rewrite the rules every single time, but like you gotta weave it all into your essay. I mean, for time's sake, we're gonna look at the model answer, but like just know like that's what I want you all to do as much as possible. Look at these previous essays, issue spot them. If you have the time, try to write the full essay. And then the most important part is what we're gonna do right now, compare to the model answer, see what they wrote, see how they wrote it, see what issues they spotted, and how they weave them into the essay, and just kind of, try to emulate that. So let's sit back, relax, chill guy vibes. I'm gonna do some light reading, a little bedtime story. So to senior lawyer from associate regarding Abby, Bob, and Sunco. All right, we're eye for an eye right there. We did the same thing. Governing law, important to note. Ooh, I like this. At the outset that they're both contracts for personal services, therefore the common law of contracts will govern the disputes, whether the UCC would govern a contract for the sale of goods. I mean, did we even mention that at all? I don't think we did. So shame on us. All right, good. Learning lesson. I mean, that has to be like, buy friends drinks, big drinks. We would have to say that these contracts are common law services, right? So can't forget that. So it's important to note. Abby's claims against Sunco. Abby will bring a cause of action against Sunco for breach of contract and for the $15,000 balance on the original agreement with Sunco. They set up just as I did, like the claim is breach of contract. Now we got to go into the issues. The first issue is whether they had a valid contract, like literally exactly how I set it up. Exactly. And I think that's for a reason, right? We're not reinventing the wheel here. The first issue is whether Abby and Sunco had a valid contract. A valid contract requires offer, acceptance, consideration, and no valid defenses. And then they have these definitions. You should all have these canned definitions. An offer manifests the power of acceptance in the offeree. The offeree must know of the offer, and the offer controls the manner of acceptance. Acceptance is the manifestation of consent to the terms of the contract and can be done in any reasonable way and within a reasonable time unless the offer specifies. Finally, consideration is the bargain for exchange of legal value. Here, so that's, the issue, the first issue, then the rules, and now the analysis. Here, Abby will assert that Bob's direct message was an offer to contract for 5 pictures with specific text in exchange for $20,000. Abby will argue that she accepted the offer when she replied to the message with "sounds great, please send me the money." Sunco will argue that she did not accept within a reasonable time because she waited 6 months to accept the offer and therefore no contract was formed. I thought it was only 1 month, but whatever. Abby will argue that this is not an unreasonable time to discover direct message on social media and that there was no time limit in the offer. Abby's acceptance was likely valid. Just for my own sake, was it 6 months? 1 month after. So like you can see, these are unedited responses. Like that annoys me just because like I guess I have OCD, but that's just fair to know. These essays are not edited, they're not perfect, but like yeah, same point. We're not losing any points, but it was technically 1 month. Okay. So she waited 1 month to accept the offer and therefore no contract was formed. Abby will argue that this is not an unreasonable time to discover DMs on social media and that there was no time limit to the offer. Abby's acceptance was likely valid. See, right, lean towards there was a contract form. Next to consideration was the posting of photos of specific text in exchange for $20,000, right? There was consideration. Therefore, valid contract was formed. The next issue, right, IRAC method, is whether there are any valid defenses to formation, right? Buy friends drinks, body of law, formation, defenses. I feel like this is one of my students. In order for a valid contract to be enforceable, there must not be any valid defenses. Here, it does not appear that there are any valid defenses. The statute of frauds requires certain contracts to be in writing, signed by the party to be charged, but this will not apply here since there's a personal service contract that can be completed in less than a year, and even if it cannot, full performance removes the contract from the statute of frauds. There's no lack of mutual assent. Therefore, there are no valid defenses to the enforcement. So it's just the contract between, the company and the Abby, the influencer. The next issue is whether Sunco breaches contract with Abby. Abby will argue that Sunco breached the contract when it did not pay full consideration. Under the common law, a contract is breached when one party has an absolute duty to perform and the duty has not been discharged. Material breach, where a party is denied the substantial benefit of the bargain, discharges the other party's duties under the contract. Minor breach, where our parties receive this, is when parties receive the substantial benefit of the bargain through imperfect performance, but does not allow for damages for defective performance. So recognize that UCC is perfect tender, common law is substantial performance. Like as long as you show up and do the song and dance, you're gonna get paid. Additionally, the plaintiff will need to show that they are ready willing, and able to perform. Sunco will argue that Abby breached because she did not include the specified text in the post, and therefore their duty has been discharged. Abby will argue that if anything, this is a minor breach and Sunco still has a duty to perform and is only entitled to damages for defective performance, which will be small since sales increase so rapidly. Abby will prevail on this argument, right? Like, do you see how they go back and forth? Abby argues this, Sunco argues that. On balance, Abby, she made them money. She should get paid. The next issue is whether the 5,000 check discharged it. Now, this is where I think, okay, so here, this is where I think Sunco has a pretty strong argument, right? We'll see. The next issue is where the $5,000 check discharged the duty to Abby. Checks are negotiable instruments, so they changed UCC Article 3. That's why this won't even be on there, but you should still know this. This is Article 3 and check. Under UCC, it's a signed, written, unconditional promise to pay a fixed sum of money with or without interest to order or bear with no additional undertaking. They're governed by Article 3 of the UCC. You don't really need to know this for essays, but you need to know it for multiple choice, so just kind of learn with me. The UCC allows for, now this is what I would be tested, an accord and satisfaction discharge the duty of a party to the contract when there's a disputed debt and a check is sent stating full satisfaction. When a check stating full satisfaction is cashed by the other parties, it is accepted as complete performance and discharges the other party's duties. The only exception is for such a check to be sent to a commercial entity or bank, which is not the case here. Here, the debt was disputed since Abby did not perform according to the terms of the contract. She dummy cashed the check, therefore accepted the accord and satisfaction and discharged Sunco the duty to pay $20,000. Therefore, Abby will not be able to recover $15,000. Unfortunately, I think that is the stronger argument here. Like, she's smart in the fact that, she knows how to get all these followers and get $20,000 checks from random bobs in the DM, but she's dumb in the sense that she cast a check that clearly stated that this was an accord and satisfaction, and she satisfied the accord. I mean, I could argue both ways, but I do think that that's the stronger argument, in my opinion.
So
Yeah, I
quick
got
question.
dinged on this in a multiple choice question in the exact opposite way. So I answered a multiple choice question in line with what this essay is saying, and it said the opposite. It was basically like simply accepting part payment, even if it states that it's payment in full, does not constitute adequate grounds for an accord and satisfaction, unless the person to whom the debt is owed explicitly states, I guess in another writing or something, that they're accepting it as full payment.
Yeah, I think that is the argument. That's why I said, you can go both ways here, but I think their argument is that it pretty much did say that here. It said like payment in full on the memo line, right?
Yeah, yeah, exactly. And I'd like that by itself from that multiple choice question. I was so pissed off about it because I agree with what the essay writer is saying. But
Yeah.
like they were saying that stating payment in full on the subject line or on the,
Actually, I know the exact MBE question you're talking about, and hopefully we'll see it tomorrow when we do questions and we can, or whenever we'll look at it. But again, that's why this is an essay and you can write both ways. So like you could say that, it wasn't a clear accord and satisfaction, or you could say that it was, and it's an essay, so you can get both points. But try not to be too frustrated about that. You had something to mention, Sean? Same thing?
Yeah, my question was also similar to Eric's, that like I had remembered like the encountering one that like that if she like for both like that, like if she didn't accept it at all, it would be clear that she could sue to get the full amount. But if she accepts it, she would still be able to get probably the full amount, because the subject line alone wouldn't be enough. There need to be something else that like either from her or so that they're trying to make it the full amount. But
Exactly. That's the argument, that the subject line alone wouldn't be enough, and that, there had to be some actual accord and satisfaction agreement. Yo, come in. There had to be some accord and satisfaction agreement. I mean, again, it's an essay, you can argue both sides. I don't know. I tend to not like that MBE question too, because it's tough. Like it does say, that's what I'm saying. Like poor Abby here. It seems to me that she full settlement, payment in full, but like, was there a true, proper, and accord and satisfaction? That's less important for today's purposes, and just so we can, kind of get through the essay. It's more about issue spotting. You have to at least recognize there was an accord and satisfaction. If you can just do that, then you should be in a good position. Okay, so here we're going to say that there was a accord and satisfaction, therefore Abby will not be able to recover. Again, I would say the court will likely find that, right? It just leaves it a little bit open to interpretation. All right, and then you see they set up just like us. They did AVS, Now they're going to do BVS. The next issue is whether Bob has a cause of action against Sunco for breach of his employment contract. Again, the elements of valid contract explained above, right? You don't get points for repeating. I like how they did that. Bob will argue that Sunco gave him an offer for employment as a marketing manager. He accepted it when he said, "You got a deal." The consideration was the payment of the annual salary with the bonus option. Therefore, there was a valid contract reduced to a writing. The next issue is whether any defenses, right? They're really doing this, properly. Remember, this is common law. We had to mention at the beginning. There's a statute of frauds defense that Sunco can assert. Contracts that cannot be completed in less than 1 year must be in writing and signed by the party to be charged. Here, the bonus option spans over 18 months, right? We caught this. However, Bob will argue that the contract could be performed in less than a year, but has a maximum of 18 months. Like they went kind of into the details. Could it be performed in less than a year? If it could, then it doesn't need to be in writing, right? That's a good argument. Additionally, Bob will argue that full performance is an exception, right? Swap, that's why I do the swap mnemonic. You can't really miss it. Partial performance is an exception to the statute of frauds provision for contracts that cannot be completed in 1 year, and Bob completed performance by meeting the agreed upon measure of sales. Bob will likely prevail on the argument since the measure is whether it could be completed with 1 year, not whether it was, and since he completed performance, not whether it was, and since he completed performance. Additionally, the employment contract itself does not satisfy the statute of frauds. Oh, it does satisfy the statute of frauds as it was reduced to a writing and signed by both parties, right? Like they went all the way through that, like oral argument, exceptions, and like, oh, and they signed a freaking agreement right after, right? It does say in the text alone that like this agreement, the next day they signed an employment agreement. So like, even though it's very obvious that there was going to be a contract, you still want to get your points, talk about statute of frauds, my legs, talk about the swap mnemonic, the more points you can get, the better. Okay. So the next issue are the terms of the contract, the parole evidence rule. This was big. Accord and satisfaction was kind of big here. Parole evidence was humongous, monstrous. So let's talk about parole evidence. The parole evidence rule bars extrinsic evidence from before or contemporaneous to formation from coming in as a term to the contract. If the contract is a final integration, like it contains a merger clause, then only evidence that explains the meaning of the contract of industry standard of the party's course of dealing or substantiates a defense to formation may come in, right? That's exactly what I said. Conditions to the contract, additional terms, industry standard, custom trade usage. These are things that could potentially come in, or a defect in formation, but not conflicting terms. If it's a partially integrated, then extrinsic evidence will be permitted unless it materially alters the term of the contract. Here, the facts indicate there was a merger clause, good vocabulary word to use that we've caught, showing that this written contract entered between Bob and Sunco was a final integration. Since this contract was a final integration, extrinsic evidence will only be permitted to explain the meaning of the contract, to dispute formation, industry standard, or course of dealing. Here, Sunco will argue that the contract was a final integration, and the option to pay a bonus of 5% of $1 million in sales is a material alteration to the contract, and one that the parties would likely have included if it existed. Bob will maybe argue that it's customary in the business to make such bonus options orally, and therefore the evidence should be permitted. Sunco will likely prevail under the parole evidence rule because the extrinsic evidence would materially change the contract unless Bob can show that it's customary or in some other way gives meaning to ambiguous terms in the contract. I mean, that's a fair argument. Like I said, again, there's not a million, but there's multiple things that you could argue. I would argue that's an additional term and that it's not a conflicting term, it's an additional, and therefore it should be integrated. This person went a different approach and said that, it's a material term and it'll most likely not be included because of the parole evidence rule. And their argument of why it may be included would be if it's seen as clarifying an ambiguous term. Whatever it may have been, it's more about saying the vocab words and having the argument. I really want people to understand that and realize that like these essays are not perfect. They're not like all right in the sense like even they use the word van with an A instead of an E, like common grammar mistakes, but like they are good and they show you what the FBBE is looking for. They're looking for robust, thorough conversations that demonstrate, understanding of the vocabulary and the conversation around the issues. All right, the next issue is whether Sunco breaches contract with Bob. Under the common law, contract is breached when one party has absolute duty to perform and the duty has not been discharged. Material breach, where a party is denied the substantial benefit of the bargain, discharges the other party's duties under the contract. There's a really good, language for breach. Minor breach, where which are where party receives a substantial benefit of the bargain through imperfect performance, does not, but allows for damages for defective performance. Additionally, the plaintiff will need to show that they are ready and willing and able to perform. Bob will argue here that Sunco breached by not paying his bonus. Bob will only be successful if he can overcome the parole evidence rule to include the bonus term in his contract. Otherwise, Sunco is not in breach. Bob may try to argue that should he pay the bonus under promissory estoppel, good job, whoever mentioned that, theory, as he relied to his detriment on the promised bonus by turning down other gainful employment options. See, they did mention that very quickly. They may have thrown that in at the last minute, but like, I thought that was definitely point worthy of, whoever mentioned that there was promissory estoppel, detrimental reliance, and what gave rise to that in our minds, the information that they said he turned down another job opportunity. And then we have Sunco's claims against Bob. Sunco seeks to enforce the non-compete agreement it has with Bob and prevent Bob from working at Spexco. It is important to note, I swear this must have been one of my students, right? Like, I was definitely teaching in 2020, and I say that all the time. It is important to note at the outset that specific performance of employment contract is usually not permitted, as it creates 13th Amendment concerns. However, injunctions to enforce valid non-compete agreements will be enforced. This is very interesting. There's actually law being written right now to eliminate non-competes at a federal level and just say that non-competes are like totally unlawful, but it hasn't really spread through the court system yet. So like, we're still writing Florida essays with this interpretation that they are enforceable so long as they're reasonable in geographic scope, subject matter, and duration. But that might change in very soon, and I'll be the first to let you know. So
Can you explain real quick the 13th Amendment, what that has to do with non-competes?
13th Amendment concerns, I mean, I would only have to interpret what they're saying. To me, the 13th Amendment prohibits discrimination in the private sector. So I guess the interpretation would be that people were using non-compete agreements in the private sector to discriminate. And that's why they were saying they were unlawful. Like, maybe, good?
Isn't it something like it kind of is like slavery if you force someone to do something?
Oh, that's a better argument too. Yeah, it's kind of like indentured servitude. You're being restricted of your rights. I'm almost done. Just give me 2 minutes. All right. See you later.
Come back. Let's go to the gym at 4.
I gotta work at 4, but I'll see you. Thank you. I gotta go. So the issue is whether the non-compete agreement is enforceable. Yeah, like we were saying, maybe non-compete, there could be an argument that it's indentured servitude or it's some form of discrimination in the private sector, whatever. That's like a really weird piece of this essay. The issue is whether the non-compete agreement is enforceable. A covenant not to compete must be aimed at protecting a valid business, reasonable in terms of geographic time and scope, and must not be contrary to public policy. Same thing. So geographic scope, subject matter, and duration. Here, Bob will argue that restricting him from working in the entire state of Florida is unreasonable, and that the covenant does not protect the valid business interest because it is not a function unique to Sunco to market goods on social media. Bob will not be able to argue that the time is unreasonable, as 6 months is presumptively reasonable in Florida. That's what I was saying. Like, up to 6 months is presumed reasonable. Over 3 years is presumed unreasonable. Anything in between is kind of like a case-by-case analysis. But again, it's always a case-by-case analysis. Sunco will argue that its marketing strategies are legitimate business interests and that the state of Florida is not an unreasonable scope, as it is big market for sunglasses. Sunco will likely succeed in enforcing the non-compete agreement, right? I said like it didn't seem terribly long, the non-compete agreement, but who knows? The next issue is whether Bob can get out of the employment contract overall in the non-compete agreement. Bob may argue that he has a valid defense of formation of the contract due to fraudulent misrepresentation. So this was we didn't mention this issue, but it's a weak argument that can't hurt. If a party is induced to contract by fraudulent misrepresentation, it's voidable by the injured party. Bob will argue that Sunco fraudulently misrepresented that he'd be eligible for a bonus in order to induce his assent to the employment contract. This is a great example of like what I'll teach in torts, like throw the kitchen sink at the reader, just like add more issues. You have 10 minutes left, keep writing. Write about, duress or liquidated damages or something. Like just write about more so you can potentially get more points. Here they're going to say that, it's fraudulent inducement and it would be voidable. Bob will argue that Sunco fraudulently misrepresented that he'd be eligible for a bonus in order to induce his assent to the employment contract. If he's successful, Bob may rescind the contract. Bob will look to restitution, right, to recover the value of the benefit conferred if his employment contract is set aside. Ultimately, it's likely that Sunco will be able to enforce the valid non-compete agreement, though Bob may be successful in having the entire contract set aside under a formation defense of fraudulent misrepresentation. So this is a really good essay, super strong. I mean, yeah, like they talked about everything. They talked about damages a little bit. I mean, the only thing that they really didn't do as much as I would have, I think, is talk about the different types of relief at contract law, which maybe they ran out of time. I mean, they talked about it a little bit, like you could maybe get the $15,000 back, but probably not. And here at the end, they were like, you could have a restitution claim. I might have spent a little bit more time just talking about what types of damage are available at contract law and what they might argue for. But you see, this was set up exactly how we were going to set it up, right? They pieced together the three different claims. They talked about what issues were relevant. You know, they didn't talk about them being a minor, 21 years old, but like it wouldn't hurt. Again, this isn't like the perfect, they got 100% on this essay. This is just an example of what a really surefire passing essay looks like. And I think this is a great example. So, you know, the only thing I think we'll add was like, maybe there was a fraudulent misrepresentation. And then damages, including, we said restitution. I mean, again, they didn't really talk about damages too much. They didn't really talk about the mitigation. Everything else they talked about, they didn't really talk about there being a condition to execution. Did the offer lapse? They said it was 6 months, it was really 1 month. I mean, they talked about everything we talked about. What do you all think? That was a pretty manageable essay. It wasn't easy, but I don't think it was impossible. Like there's definitely harder essays you're gonna encounter, real property, con law type essays. So you should be like pretty okay with that and you know, ready for it on test day.
Real quick, can you go through the issues and like identify which ones are the absolute must-haves and which ones are for extra points?
From that essay? I mean, yeah, sure. Like obviously we had to identify if it was common law, right? Like you have to identify the body of law. We definitely had to do the offer, acceptance, and consideration right there. Like you can't not talk about those things when you're talking about contract law. And you know, if we didn't mention these things explicitly in our issues, we should have, because that helps you not forget when you write about it. So offer, acceptance, consideration were certainly important. I mean, this one definitely talked about accord and satisfaction, because there was like a payment and then a payment to pay less. So you had to talk about accord and satisfaction. Parole evidence was major. This one was like super important to talk about parole evidence. And then obviously the non-compete being these three things. Like if you didn't know that and you had nothing to talk about in the non-compete agreement, you were pretty much cooked. I would say that's it. Like those were the main issues this one was testing was, you know, body of law, contract formation, and then defenses. I mean, we talked about statute of frauds somewhere, right?
The 18 months in the first one.
Yeah. Oh yeah, statute of frauds 18 months. I think honestly, I would mention that part too. So those are the main things. I mean, to me, this was a regular contracts essay, some kind of like tougher subjects that they were testing about that people might not have been prepared for would have been parole evidence and accord and satisfaction. But like, I don't think those are like supremely difficult, you know, subtopics. So what I'm going to do is stop this recording. I know there might be some questions in the chat, or y'all might have some questions for me. That's fine. I'll stick around for a bit, but I'm definitely gonna stop this recording.